The United Nations has spearheaded a number of agreements that pertain to Aboriginal rights. These agreements respect the unique relationship between Indigenous people and the land, and to protect Indigenous people's rights to use, protect, and own the lands. Even though Canada has signed on to some of these agreements, interestingly, our government does not recognize all of them as binding international law. The Canadian government and the BC government are required to consult with First Nations regarding resource development on their traditional territories. This is because of landmark legal cases which set a legal precedent for what is called the duty to consult. The most well-known of these cases is Haida versus the Ministry of Forests of British Columbia. In this case, the government of BC approved the transfer of a tree farm license to a new owner without consulting the Haida. But the Haida had long claimed title to that area. The case went all the way to the Supreme Court of Canada, which unanimously decided that the government's duty to consult with Aboriginal peoples and accommodate their interests is grounded in the honor of the Crown. In other words, if the Crown knows that a First Nation is claiming title to an area, it must consult with that First Nation before making any decisions that will affect the First Nation's claim on the area. Now in BC, the duty to consult comes into play regarding mining activities. But there are no BC or Canadian laws that outline a clear process for this consultation. This section examines the duty to consult in more detail and describes a series of best practices for First Nations. Specific case examples can be found throughout the appendix of the Mine Medicine Manual.